To understand mediation under the Consumer Protection Act, some basic information, some basic definitions you should know. That is, who is a consumer under Consumer Protection Act, what is defect in goods, deficiency in service, unfair contract, unfair trade practice, restrictive trade practice. I'm not going in depth into these words, just I'm giving you gist of these words. Whosoever purchases goods, hiring the services for consideration, that person is called as a consumer under Consumer Protection Act. And the definitions gives details in what circumstances any contract becomes an unfair contract and what type of trade practices are considered as an unfair trade practice, and also restrictive trade practice. One example I can give for unfair trade practice, that is misleading advertisements. Like that, many examples are covered under the unfair trade practice. So the good or product which is purchased for consideration, if it is not working, if it is not as per the standards mentioned under the laws. Similarly, services which are not standard as mentioned under the law, that is also considered as a deficiency in service. In case of goods, it is considered as a defect in goods. In case of services, it is considered as a deficiency in service. Whenever person purchases goods for consideration, hires service for consideration, if it is a defect in goods, if it is a deficiency in service, and if it is unfair contract, if it is unfair trade practice, if it is a restrictive trade practice, consumer can approach Consumer Commission. He can file a complaint before the district commission or state commission or national commission, depending on pecuniary jurisdiction and territorial jurisdiction. So that is the thing one must know. Pecuniary jurisdiction is every district throughout India. We can say throughout India, every district must have a district consumer commission. Every state must have a state consumer commission, and every at the national level, national consumer commission. So these commissions are protecting the consumers, whosoever approaches them. So under this table, I have given a pecuniary jurisdiction. Whosoever purchases a goods or hires a service, whatever amount is paid on that basis, that is called value of the goods or service. On that basis, one must decide where that complaint can be filed for defective in goods or deficiency in service or unfair trade practice. Up to 50 lakh rupees, it should be before the district consumer commission, and above 50 lakh up to 1 crore, it is before the state consumer commission, and above 1 crore, that is before the national consumer commission. So this is a pecuniary jurisdiction. And also you have to look into the territorial jurisdiction. So where you can file a complaint. One is on the basis of pecuniary jurisdiction, another one is on the territorial jurisdiction, where opposite party resides, works for gain, carries on business. There he can file a complaint. Or where cause of action or wholly or in part arises, there the consumer can file a complaint. Under the new act, new clause is added that is where complainant resides or personally works for gain, their consumer can file a complaint. So you have to look into the pecuniary as well as territorial jurisdiction. Coming back to the mediation, once you understood the basics, then let us come back section 37 of Consumer Protection Act. When you have filed the complaint before the district commission or state commission, national commission, depending on the pecuniary jurisdiction and territorial jurisdiction, what commission has to do. So this section 37 talks about when mediation, when the commission can refer the dispute for the mediation. Clause 1 talk about at the first hearing of the complaint after its admission or at any later stage, if commission feels that there is a element of settlement which may be acceptable to the parties, except in such cases as may be prescribed, it may direct the parties to give in writing within 5 days consent to have their dispute settled by mediation in accordance with the provisions of Chapter 5. Where the parties agree for settlement by mediation and give their consent in writing to the commission within 5 days of the receipt of such consent, refer the matter for mediation. And in such cases, the provisions of Chapter 5 relating to mediation shall apply. Even though Section 37 talks about the district commission, but this particular section, even it is equally applicable to the state commission as well as national commission. So gist of this section is, once the case comes before the consumer commission, if consumer commission feels that the facts can be, this particular dispute can be settled through mediation and parties are also agreeing, then that dispute can be referred to mediation. In that case, the commission can ask the parties to submit their consent in written form. Once they submit the consent in written form for mediation, then within 5 days of receipt of such a consent, it can be referred to mediation. So this particular section 37 is very, very important. One must know that mediation is a voluntary process, and entering mediation, once you enter the mediation process, it is not mandatory for you to settle the matter through mediation only. No. At any stage, if you feel that mediation is not suitable or not good for you, then you can tell the mediator, I'm not continuing with the mediation, I want to go back to the court, commission. So you can at any stage come out from the mediation procedure. So that voluntariness is with the mediation method. If you are happy, settlement happens, both parties will agree on their own terms and conditions, both parties will sign, mediator will sign, that becomes the final settlement, and that settlement document will be submitted to the consumer commission, and consumer commission puts its seal and signature. That becomes the final award. And once the commission puts its seal and signature, it becomes a decree of a civil court, and it is enforceable as if it's a decree of civil court. Hence, there is no appeal against the mediation settlement because it is settled through voluntariness. No force is involved. Hence, it is a final. No appeal is allowed. As I have mentioned, if a party is not happy with the procedure, or outcome, at any stage they can come out from the mediation procedure. Once it comes out, then section 38 is applicable. So district commission, again 38 is applicable. The content of section 38 is equally applicable to the state commission and national commission. So whichever case came back from the mediation, that is because of failure of settlement by mediation, those cases will continue from that stage where it was stopped and went for mediation. From the same stage, it will continue further in consumer before the consumer commission. Let us come back chapter 5. Already all those sections under chapter 5 already discussed. Section 74 talks about establishment of consumer mediation cell. As I have mentioned, that state government shall establish by notification consumer mediation cell to be attached to each of the district commission and state commission of the state. As you know, district commissions and state commission is under the control of state government. It is not under the control of the High Court of that particular state. Hence, it is the duty of the state government to establish mediation cell at the district level and at the state level. It is mandatory. Similarly, National Consumer Commission is under the control of central government, not under the control of Supreme Court of India. There also, central government should establish the mediation cell at the National Commission, and if it is a regional benches, there also. Presently, we don't have a regional benches. It is only in New Delhi. Then consumer mediation cell shall consist of such persons as may be prescribed under the rules, and every mediation cell shall maintain the list of empaneled mediators, list of cases handled by the cell, record of proceedings, any other information as may be specified by regulations. Every consumer mediation cell shall submit a quarterly report to the district commission, state commission, national commission to which it is attached in the manner specified by regulation. Here, the whole chapter 5, you have to understand these sections along with the mediation rules 2020, mediation regulations 2020. If you look into these sections along with rules and regulations, then you will get a comprehensive view of the mediation under Consumer Protection Act. Section 75, empanelment of mediators. So it is the duty of the National Commission, State Commission, District Commission. They have to invite applications from eligible candidates through advertisement, and once the application comes, scrutinize it as per the rules and regulations, and once you select those applicants who have undergone the 40 hours training program, who are suitable for this particular mediation under the Consumer Protection Act. So those selected persons' name should be announced on the website, and whenever case comes before the commission, they can refer the name which is suitable for that particular dispute as a mediator. So it is the duty of the commission to prepare empanelment of the mediators. The qualifications and experience required for the empanelment as a mediator, so that has to be the procedure for empanelment, the manner of training empanelment mediator, the fee payable to the empanelment mediator, the terms and conditions for empanelment, the code of conduct for empanelment of mediator, the grounds on which the manner in which empaneled mediator shall be removed or empaneled shall be cancelled, or other matters relating thereto shall be such as may be prescribed by regulations. So details are given under regulations. If you look into these sections, in all the sections they have referred in some places rules, some places the regulations. So that's why you have to look into those rules and regulations to understand these sections. Clause 3 of section 75 talks about panel of mediators prepared under clause 1 of this particular section shall be valid for a period of 5 years. Once a mediator name is entered in empanelment of mediators before any of these three commissions, that period is for the 5 years. The empaneled mediator shall be eligible to be considered for re-empanelment for another term subject to such conditions as may be prescribed by the regulations. So depending on how that mediator worked in past 5 years, on that basis his name may be re-empaneled in the next 5 years. So that's why mediators, how they behave, how they follow the rules and regulations, so all those things counted at the time of re-empanelment. Section 76 talks about nomination of mediators from panel. So when complaint is filed before the commission, depending on the nature of the dispute, the commission can decide which mediator whose name is in the empanel, that person can be nominated for that particular dispute for the that particular mediator will take that particular dispute, contact those the parties, disputing parties, and that person will continue to that particular dispute to settle the dispute through mediation. I'm giving you one example, the same way it has happened in the National Consumer Dispute Redressal Commission. Actual name is longer. Full name is National Consumer Dispute Redressal Commission. In short form, we call it as a National Commission, at the state level State Commission, and at the district level District Commission. So here also National Commission invited application who are eligible to become a mediators, and throughout India it was advertised on the website. Throughout India, whoever interested to be empaneled mediators, they applied in a particular format, and along with the training certificate, 40 hours training certificates, and the affidavit, all together they have to submit to the National Commission. National Commission will scrutinize who are eligible. So those candidates, they will intimate that your name is selected for the panel of mediators. Are you interested? If you are interested, give your consent. Once they give the consent, their name will be entered like this. And if you look into the serial application number 129, my name is also there. So I'm also empaneled mediator before the National Consumer Commission. Then section 77, duty of mediator to disclose certain facts. As you know, mediation is a process which is depending on the trust between the mediator and the parties. Hence, mediator has to disclose that he is a neutral and he is not having any interest in the parties or the interest in the dispute. So he has to disclose. So that's why section 77, it shall be the duty of the mediator to disclose any personal, professional or financial interest in the outcome of the consumer dispute. The circumstances which may give rise to a justifiable doubt as to his independence and impartiality. Such other facts as may be specified by regulations. So all those things should be disclosed before starting the mediation. So it is the duty of the mediator to disclose these concerned facts. So more details are given under the regulations. Section 78 talks about replacement of mediator in certain cases. As I have mentioned, mediation is a voluntary process. It is left to the parties to the dispute to continue or not. Here is a case disputing parties are interested to settle the matter through mediation, and mediator is also appointed, but during the mediation proceedings, sometimes any party feels that that particular mediator is not following the rules, then they can inform to the district commission, state commission, national commission, wherever the case is referred. So that is section 78. Where the consumer district commission or state commission, national commission, as the case may be, is satisfied on the information furnished by the mediator or on the information received from any other person, including parties to the complaint, and after hearing the mediator, it shall replace such mediator by another mediator. Because once one of the parties is not happy with the mediator, you cannot expect the settlement. So that's why it's a better clarify that particular confusion by giving the hearing to the mediator. And if it is the party is not happy with the proceedings or maybe any other reasons, then the commission will replace that mediator by another mediator who is in the list. Ultimately, it is in the interest of the parties, in the interest of success in the mediation procedure. Section 79 talks about procedure for mediation. What procedure should be followed during the mediation? Mediation shall be held in the consumer mediation cell attached to the district commission, the state commission, national commission, as the case may be. Then consumer dispute is referred for mediation by district commission or state commission, national commission, as the case may be. Mediator nominated by such commission shall have regard to the rights and obligation of the parties, the usage of trade, if any, the circumstances giving rise to the consumer dispute, and such other relevant factors as he may deem necessary, and shall be guided by the principles of natural justice while carrying out a mediation. So here, once the mediator is named or nominated for a particular dispute, then the mediator has to respect rights and obligations of the parties, and also he should follow natural justice principles. This is very, very important. Natural justice principles. Both parties should be allowed or given opportunity to share their views personally in a separate sessions or jointly. So that has to be allowed, cooperated during the mediation procedure. The mediator so nominated shall conduct mediation within such time and in such manner as may be prescribed by the regulation. So this mediation alternative method is followed because it's a quick one, less expensive. Within short time settlement happens, and parties have a control over the mediation procedure. Whatever they want in the procedure is followed. So time is the essence, and that's why within a given time the case has to be, this mediation has to be completed. So the details are given again under the regulations. Section 80 talks about settlement through mediation. Through the pursuant to the mediation, if an agreement is reached between the parties with respect to all of the issues involved in the consumer dispute, or with respect to only some of the issues, the terms of such agreement shall be reduced to writing accordingly and signed by the parties to such dispute or their authorized representatives. The mediator shall prepare settlement report of the settlement and forward the signed agreement along with the such report to the concerned commission. Where no agreement is reached between the parties within the specified time, or the mediator is of the opinion that settlement is not possible, he shall prepare his report accordingly and submit the same to the concerned commission. So the gist of this particular section 80, assume that there is a dispute and 5 issues are involved, and don't expect that all 5 issues should be settled, then only it's a successful mediation. Yes, if all 5 are settled, it's a good, but even some issues are settled, then also to that extent mediation settlement can be done. Example, if 5 issues are there, both parties are agreed for settlement on 3 issues. On those 3 issues, settlement deed can be made, and rest of the 2 issues on which both parties are not agreed, those can be goes back to the commission to continue with the commission procedure. So whatever issues are settled, on that basis settlement report is prepared. And if assume that all 5 issues are settled, then all those 5 issues should be written on a paper. Both parties have to sign agreeing or giving consent that whatever 5 issues are settlement terms and conditions are mentioned in the paper, they are agreeing, giving consent through sign on the agreement, and also the mediator also sign on that, and then mediator submits that report to the concerned commission, and concerned commission puts its seal and signature. That becomes the decision of the consumer commission, which is not which is final and not appealable, because it is settled through voluntarily. And another thing, in the settlement report, there is no need for mediator to mention whatever happens during the mediation. All those details are not mentioned in the report. Only operative portion of the settlement should be mentioned. So that's why sometimes these whatever happens during the mediation procedure, it will not be to the open to the public. So it will be confidential, and only operative portion is on public. So last clause talks about where no agreement is reached between the parties. So both parties are not ready to settle. Mediator tried his level best to understand the situation, try to bring them on neutralize their mindset, and try to bring them on a settlement. But ultimately, if parties are not ready, he cannot force them. Hence, even on the no agreement is reached, that report also the mediator has to prepare. And sometimes even they are not coming forward, they are not cooperating, then also if mediator feels that it may not be settled through mediation, he can prepare his report and submit to the concerned commission. Then section 81 talks about recording settlement and passing of order. Clause 1 talks about district commission or state commission, national commission, as the case may be, shall within 7 days of the receipt of the settlement report pass suitable order recording such settlement of consumer dispute and dispose of the matter accordingly. Second clause, where the consumer dispute is settled only in part, the district commission, state commission, national commission, as the case may be, shall records settlement of the issues which have been so settled and continue to hear other issues involved in such a consumer dispute. Third clause, where the consumer dispute could not be settled by mediation, the district commission, state commission, or national commission, as the case may be, shall continue to hear all the issues involved in such consumer dispute. The gist of section 81 is, once the mediator submit its report, maybe fully settlement done, both parties have signed, then once they submit a report, once the mediator submits a report, within 7 days from the receipt of a settlement report, commission should pass a order or recording such settlement of a consumer dispute and dispose of the case accordingly. Second type, where the mediation, through mediation, partly consumer dispute is settled. To that extent, the consumer commission, district commission, can pass a order, and rest of the other issues where they have not settled, that can be continued. And third type, where the mediation is failed, the settlement is not done through mediation, then the commission should continue, shall continue to hear all the issues involved in such consumer dispute. So on at which stage it has gone to mediation and mediation is failed, comes back to the same commission where it was stopped. From that particular stage, it will continue as per the Consumer Protection Act. So that is the procedure followed. So this is about the chapter 5, and also nowadays Niti Aayog, Government of India, and even Supreme Court are encouraging online dispute resolution, and whatever the physical mediation procedures, ethics, code, conduct, all those things are followed. Similarly, that is followed in online dispute resolution. And now it is picking up, and in future we may follow the online dispute resolution, because everybody is busy, and nowadays everybody is having a electronic gadget, mobile laptop. It is easy for them to settle the matter online. In that regard, government of India established a mediation center at National Law School, and we are running this particular online consumer mediation center at National Law School, and whatever cases, disputes referred from National Commission, State Commission, District Commission, we are settling those disputes through mediation, online mediation. And even our infrastructure, state of art infrastructure is allowed, or even physical mediation also. And as I have mentioned, online dispute resolution is also recognized by the Ministry of Law and Justice, Government of India. They invited all mediation centers throughout India and discussed with us. I also went and discussed how best we can use online dispute resolution to settle the matters amicably, even before the consumer commission, or even before the regular court.